Thank you, Mr. Chairman. Register Perlmutter, thank you for being here. You do a great job, and your 444 employees are well served. I want to go back to the subject of a hearing we had back in July, the DMCA and Section 1201 and right to repair. The DMCA was introduced back in '98 to address the evolving relationship between copyright, the internet, and emerging technologies, and Section 1201, as you know, prohibits the circumvention of technological protection measures designed to safeguard copyrighted works. Your office oversees a triennial rulemaking process pursuant to the DMCA to grant specific exemptions to 1201, balancing copyright protection with technological advancement. Some have called for a reform of this process, particularly those who rely on exemptions to enable third-party repair of devices with TPMs. With respect to those issues, do you believe that Section 1201 should be modified statutorily, or do you think the Copyright Office's rulemaking authority is sufficient to address the needs of copyright holders and consumers?
My answer would really be both. We are able, through the rulemaking, to address the right to repair issue, and we have done it in, I think, the last 3 successive rulemakings. On the other hand, that's not the most efficient way to do it. It requires a lot of work from stakeholders and from the Copyright Office every 3 years. And for that reason, in our report on Section 1201 a few years ago, we did recommend a statutory permanent exemption for the right to repair in appropriate circumstances, and we still believe that would be advisable.
Can you talk about what are the most important reasons that led to your office's decision to expand those exemptions in that space?
We did hear that there were many situations where, because copyrighted software is incorporated into devices of various kinds, and because it is protected by encryption or other technological measures, that the DMCA's prohibition on circumventing technological measures made it impossible for people to get access for purposes of repair. So for that reason, in particular contexts, which were medical devices, consumer devices, and vehicles, we did put in place, we recommended to the Librarian of Congress, and she put in place, I should say, exemptions allowing circumvention in those situations in order to make repairs. We continue to believe that's a valuable tool for people to have, and therefore we would support addressing it in a permanent way rather than through a triennial rulemaking.
So in your view, this expansion could lead to a proliferation of third-party repair shops and emergence of a more competitive and robust repair industry?
It may, yes.
Now that you've recently initiated your 9th triennial rulemaking process, we know that petitions for renewing existing exemptions and new exemptions were due August 25th. Can you offer any insight into new exemptions that are being requested and how they compare to requests over the past several rulemakings?
We've had a few new requests, not a deluge of them. We never know until we get them. We will be issuing a notice of proposed rulemaking in October, which will set out our recommendations on all of the requests. But I don't think anything will be a tremendous surprise. There are a number of requests to renew existing exemptions or expand them, and just a few new ones, not a lot.
Okay. Talking about TPMs, rights holders argue that aside from protecting IP, TPMs ensure device safety, security, and reliability. What has your office found in terms of whether the increased granting of exemptions weaken IP rights for owners and present security issues for consumers?
We have not been made aware of any serious problems arising from any of the exemptions that the librarian has granted. So far, what we have recommended and the librarian has adopted have been very carefully delineated exceptions that are drafted in such a way that we believe avoids negative impacts.
Great, thank you. I yield back.
Thank the gentleman. We now go to the chairman or the ranking